It is May 26th of 2026, and this is the Court Gallery. Today, a defendant tries to explain his years-long absence from probation by revealing he was living off the grid in a cabin in the woods to avoid the police. Later, a judge has some serious questions when a defendant who claims she's broke and needs a public defender somehow comes up with thousands of dollars for bond, leading him to declare, "Not on my watch," and stick around for a man who attempts to get his traffic ticket dismissed using the Indiana Bill of Rights in Washington State. These cases are stranger than fiction, ladies and gentlemen, and it all starts right now.
Court calls the people of the state of Michigan versus Paul Brian Van Horn. Case number 224004 SM. Mr. Van Horn joins us in the courtroom. Mr. Rupp joins us by Zoom, and Ms. Dole joins us in the courtroom as well. Counsel, just a reminder that I'm only sitting on the probation violation hearing. Mr. Van Horn does have two other files that I'm conflicted out of. Unless there's a waiver, which we haven't received yet. So, Mr. Rupp, where do we stand today in regards to the violation hearing?
Judge, with regard to the violation, my understanding is that it's based on a failure to report testing positive back in 2023, engaging in new criminal activity, and absconding. If the prosecution and probation were willing to forego the new criminal activity just because those matters are still pending, it's my understanding that Mr. Van Horn would be otherwise prepared to acknowledge the violations.
So I just want to make sure I'm clear. He would plead to fail to test as directed on April 10th, fail to report as directed on April 10th of 23, testing positive for amphetamine and THC on January 25th of 23, testing positive for THC on March 21st, 28th, and April 1st, all of 23. And what about the absconding?
I believe he's prepared to acknowledge that as well.
All right. Ms. Dole? Sure.
Governor, the people would be in agreement to dismiss the criminal behavior, both counts of new criminal behavior, if you were to plead guilty to fail to report positive witness. All of the dates mentioned and the failure to report over 60 days.
All right. So, Mr. Rupp, it sounds like that's an acceptance of your offer, or is that how you wish to proceed?
I would ask that Mr. Van Horn confirm, but that's my understanding, yes.
All right. Mr. Van Horn, will you please raise your right hand as best as you're able? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? All right, you may put your hand down. So it's my understanding that you plan on pleading guilty to the probation violations, would be technical violations, that you failed to test as directed on April 10th of 23, failed to report as directed on April 10th of 23, tested positive for amphetamine and THC on January 25th of 23, that you tested positive for THC on March 21st of 23, March 28th of 23, and April 1st of 23, and that you also absconded for over 60 days from probation. The people would dismiss the violations of new criminal behavior, so non-technical violations of domestic violence, aggravated second, and habitual offender second, as reported by the Wexford County Sheriff's Department on September 27th of 23. Domestic violence, aggravated domestic violence, third offense, habitual offender second. Looks like those were the only two that would be dismissed. Is that your understanding of what's happening today? Is that how you wish to resolve this matter? Has anybody promised you anything in order to get you to plead?
No.
Has anybody threatened you in any way? And is it your own free choice to plead? Are counsel aware of any promises, threats, or inducements that have not been made part of the record?
No, Your Honor.
All right. Then, Mr. Van Horn, to the allegation that you violated your probation by failing to test as directed on April 10th, 2023, how do you plead?
Guilty.
And that you failed to report as directed on April 10th, 2023, how do you plead?
Guilty.
That you tested positive for amphetamine and THC on January 25th of 23, how do you plead? And that you tested positive for THC on March 21st, 23, March 28th, 23, and April 1st, 2023. And how do you plead to absconding from probation for over 60 days?
Guilty.
All right. In order to accept those pleas, I must have you tell me what it is that makes you guilty. So as a condition of your probation, you knew that you were supposed to report as ordered. And did you also know that you weren't supposed to use controlled substances and test randomly?
Yes, Your Honor.
Did you in fact miss a report on April 10th of 23?
Yes.
Did you know you were supposed to report on April 10th of 23?
I'm not sure on that, but I'm sure I probably did.
If it's reported that you were supposed to report, do you have any reason to doubt that you were supposed to report? And do you have any reason to doubt that report day would have been a test day as well?
Oh, no.
Is it true then that you also tested positive for amphetamine and THC on January 25th of 23?
Yes.
And is that because you had used those substances?
What had happened there, Your Honor, is my oldest son had went to a party.
Okay.
And there was some marijuana on the table. Kid there didn't smoke marijuana. He told my son he could have it. Brought it home. He put it in a little cellophane that was on the table. There was other people that were using that. Apparently, when I admit I smoked the marijuana, that's some residue in my cellophane. I wanted to test positive. And I understood it was a low grade, and I did get violated that day for it. I did smoke the marijuana. I don't know if they smoked marijuana that day, but I didn't know if they smoked.
Okay. But you knew it was a term of your probation not to smoke marijuana.
Not to smoke marijuana.
All right. And is it also true then that you tested positive for THC on March 21st, 28th, and April 1st of all of 23?
Yes.
Again, is that because you had smoked marijuana?
Yes.
And then it is also true that you had absconded for over 60 days from probation.
Yes.
You recall when your last report date was?
I do not. I know it was like 3 years ago or something, so I don't remember exactly.
Did you report at all after that April 10th report date that you missed? All right. Do counsel believe defendants provided a factual basis in which to accept a plea and that the court rule has been complied with?
Yes, Your Honor.
Defense is satisfied.
The court agrees. I find the pleas are knowing, voluntary, and accurate. Mr. Van Horn, I find you guilty of violating probation. In particular, I find that you're guilty of one non-technical for absconding for over 60 days. I will treat counts 1 and 2 of the April 10th date, all arising out of the same occurrence. I'll treat that as one violation. And then the violation for the positive tests. So that'd be I believe that's 5 technical violations and 1 non-technical. Has everybody received Ms. Bismack's amended probation report recommendation? Looks like it was dated May 14th.
Judge, I have not seen that, Your Honor.
You've not seen that?
There's another one dated May 19th.
Okay, I don't have the May 19th one. So Ms. Ms. Dull, you don't have your computer with you, do you?
I do not have the computer with me. I can bring.
Yeah, if we can get a copy, and Mr. Rupp will email you a copy while we're doing this right now.
Judge, if I may, while we're waiting, I did meet with Mr. Van Horn last week, I believe on Thursday via Zoom, and I discussed with him the other two matters and your conflict. It's my understanding, although I don't have a signature from him on the form that was provided to me because I was meeting with him remotely. It is my understanding that he's prepared to waive that conflict so that you can preside over those two files and get those exams scheduled.
Mr. Van Horn, is that accurate? So do you understand that, and I know we discussed this last time, but the reason for the conflict is that I was the elected prosecutor at the time that these charges arose. One is from 24 and the other is from 23. I was not the, looks like my only involvement was being the elected prosecutor. The chief, I'm sorry, who is now the chief assistant prosecutor was the assistant prosecutor. He's the person who signed the complaints. And I will tell you that I have no recollection at all of these cases. Knowing all that, then do you still wish for me to preside as a judge?
Yeah, it seems pretty fair, so I shouldn't keep you as judge.
And have you had adequate opportunity to discuss that with Mr. Rupp?
Yes,
And you feel confident in that decision?
yes.
So, Mr. Rupp, you had the form on these?
They were emailed to me, yes.
All right. Mr. Van Horn, will you give your permission to your attorney to sign your name to those waivers on your behalf? Mr. Rupp, if you're comfortable doing that, he's given you permission, I will accept that, but I'll certainly leave that up to you as to whether or not you want to do it that way.
I'm comfortable with proceeding that way, and we'll get those forwarded to you later today.
Okay. Oh, I'm sorry.
Be forwarded to me. Yes, we waive, but could those be forwarded to me so I could sign as well and file a report?
Yes.
Will do. I have had a chance to review that, Your Honor.
Does either side have any corrections other than one Ms. Bismack just pointed out?
I have no corrections, but would appreciate allocution.
Yes, I'll give that to you in just a moment. Ms. Bismack, just asking, now that the new criminal behavior was dismissed as part of the plea agreement, does your recommendation change at all?
No.
All right, fair enough. Mr. Rupp, any allocution?
Judge, obviously, based on the violations that were just admitted to and the factual basis provided to Mr. Van Horn, he had some continuing issues with controlled substances, in particular THC. Although amphetamines came into the mix, he explained that that was not something he did knowingly and intentionally, but did acknowledge having consumed or used THC that had been tainted without his knowledge. I believe that the reason for the stoppage of reporting and disappearing for a period of time was he was scared and went to live in a cabin in the woods for a couple of years. Obviously, the prosecution and probation will disagree about new criminal activity, but it is our position that he did not engage in those things, and that that there's a valid legal defense for any involvement he may have had. He's been gainfully employed working with Dave Casey at the towing company, Affordable and Advanced. He does maintenance and custodial work, and he does work in the shop for them. I believe, or at least based on what Mr. Van Horn tells me, he was arrested on April 29th, so he's been in jail for almost a month at this point. I don't have any issue with terminating his probation unsuccessfully, but would encourage the court to limit the custodial sentence to time served.
All right, thank you. Ms. Dahl?
Your Honor, I don't believe he is candidate for further supervision. He is obviously not taking probation seriously, although he may have continued to stay in the area and find employment here, he did not avail himself to his obligations under the probation order. Additionally, I believe the court previously, as part of sentencing in this case, suspended 90 days. So I would ask the court to impose those 90 days previously suspended based on his failures to comply with probation and then absconding for years. I believe the recommendation is appropriate. Thank you.
Thank you. Mr. Van Horn, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
Just that, again, before all this happened, I don't know if the court is aware that my daughter was brutally murdered. But never told me anything about that. And my whole family went through a hard time. All the kids. I included myself for some reason. I was, smoke marijuana. And I was a severe alcoholic. And a heroin addict. I just recently got off of all that at the time. And, I was still using marijuana to keep me off of pills and all that stuff that I was really had a problem with. And I had fully in an oxygen. So because of it, and but I quit that, still using the marijuana. I never paid it for my mental health, but obviously, but why using it.
Are you still using it? When did you stop? Okay, all right. Fair enough. And how long ago was your daughter killed?
Been 3-4 years ago now.
Was that around here?
Yeah, she was killed in South Bend.
Oh, okay. All right. I had not heard that. I'm sorry for your loss. Is there anything else you'd like me to consider? I have a question for court staff because I'm looking at the prior orders in this case. And is it correct he was just placed on probation for one count of domestic? He was convicted of 2.
Should have been put on for both.
And then the prior judgment only sentenced him to jail on count 3. But he was convicted of counts 3 and 4.
Oh, 3 and 4. Yeah.
All right, so counsel, I'm just looking at the prior judgment of sentence on this. That was before I became the judge, and it shows that he was convicted of counts 3 and 4, which were both domestic violence, pled no contest. However, he was only sentenced on count 3 and placed on probation for just one count of domestic violence, but it doesn't say what count, correct?
Looks like it got put on count 3.
I'm being told it's count 3 he was put on probation. So unless there's an objection, because the original order was just for count 3, I'm going to consider this a violation against count 3. I'm going to consider that he was not put on probation for count 4, at least through the paper trail. But when I impose a sentence, I can't do that because I'd have to put him on probation for both. Mr. Rupp, any suggestion how to proceed on this issue?
So I do have the judgment of sentence in front of me. I had not noticed what you've been describing. So I would say this is a novel situation for me. The court speaks through its orders. So if he wasn't imposed probation or any kind of jail time on count 4, it makes sense to me that whatever violation is imposed now should only be applicable to count 3.
Ms. Dahl?
I agree with that, Your Honor.
All right. All right, so Mr. Van Horn, unfortunately, there's a little, fortunate for you, unfortunate for the court system, there was a little bit of a mix-up in your paperwork. When it was generated back in 22, it's like one of the counts dropped off the paperwork and you hadn't really been sentenced on that. It shows you were convicted on 2 counts, but as far as your sentence, it only shows on 1 count. So what I'm going to do is, because you were only placed on probation for 1 count, I'm going to take that into account when it comes time for sentencing. Mr. Rupp and Ms. Dahl, because this appears, it looks like he was never sentenced on count 4. So is there any objection to me just sentencing him to the 1 day that he would have received on count 4?
I believe he was sentenced on count 4 because there was a fine imposed as to count 4.
But there was no jail time imposed.
But that doesn't necessarily mean he wasn't sentenced, so I believe that he only got jail time on count 3.
Okay.
But there was a count 4 Justice System Fund imposed, so I believe he was sentenced on count 4.
Okay. All right.
So
So then I'll just proceed on the count 3 then. Other than he doesn't get credit on count 4 for any jail time because there wasn't a jail time imposed on that. All right. Mr. Van Horn, just out of curiosity, how did you come to be picked up? Did you have law enforcement involvement or?
I was I just started doing like polishing rocks and selling passing stones and stuff. My nephew, he has stage 4 cancer. Got on through like Madrid is. He doesn't have one good, so I was just helping him. We were on the side of the road. And some older gentleman came up and started screaming and yelling at us, saying that we were on the property. So we left and I just apologized to the gentleman. We left and we went to our family's gravel pit. And we're looking there. I got the gentleman and called the police. And they come pulling that on, the family property. And I was standing there. They knew I was wanted. Don was done tired of running. I mean, I have a job now. I just want to get this behind me so I can go back to work. I lived in the woods, lived in a cabin. I finally am trying to get back on my feet to get out of that situation. And so I can be a part of the community again. I miss going to my church. And miss, a lot of things. I miss my family. Living in the woods is horrible. I put this whenever the court closed on these young days, all you to be happy to living out there. It's horrible. I just want to be able to get back to work and get be hard. I finally have a place to live and a job. And I just don't want to lose my place to live and a job. I'm tired of running. I know what I did was wrong. I know what I did was wrong. I know that, I've got to get myself straightened out so I can be, back to where I was. I wasn't doing talks at the schools about the kids, about the effects of drugs and alcohol, what it did to me, about, how I lost my daughter. Talks at churches. I actually helped with all the 3 kids, come forward, about stuff that was going on at home, with them. And it was real good to finally be able to help people, So I'd be able to, get back to work and get back to a normal life. I don't want to lose my job and finally have a place to live again. So I don't have to go back to the woods.
All right. Well, the prior judge had imposed a sentence of 90 days with 1 day credit. However, that 90 days was suspended. So my hands are somewhat tied here. So the sentence today, I'm going to revoke probation. I believe that's appropriate given the absconding for more than 60 days. I'm going to impose the 90 days jail with credit for 27. Fines were previously assessed in this case by the prior court. As referenced in the judgment, I believe those fines and costs were appropriate at the time. I still believe they're appropriate today, so I will preserve the fines and costs. Ms. Dull, anything I've missed in a judgment or an order following the violation? Rupp, anything I've missed?
No, Your Honor.
All right, I will sign that. Mr. Van Horn, you'll need to go with the bailiff, and we'll get your other cases back on my docket, and we'll get them back on as soon as we can. Thank you. We are adjourned on that matter.
Thank you, Your Honor.
Thank you.
Court does call the case of the people versus Emmanuel Onichukwu.
Good afternoon, Your Honor. We're over. We have people. We have to go to how they believe it's on Zoom.
Sir, can you please state your name?
Emmanuel Uduchukwu.
Time for defendant's motion. I don't.
Yes, today's the date and time for our Walker motion to preclude statements that Mr. Uduchukwu made to the police at a interrogation, well, de facto interrogation. Do the people have a witness? It's our motion, but I believe it's the people's burden, my understanding of Walker. I don't know.
Well, I have to first of all determine that a Walker hearing would be necessary.
Okay,
I mean, I think that's the first step.
okay. You can make
And
that.
if I do, then we'll go from there.
All right, so I can make my,
You can make your motion as to why you make your argument as to why you believe that you'd be entitled to a Walker hearing.
so at the time of the interrogation, my client was under 18. Not read any Miranda rights. The police officers presented themselves to his home.
Well, Miranda is only going to apply to a custodial interrogation, right?
Right, so, but just because he's not in the police precinct doesn't necessarily mean that he had control over himself or the other individuals in the room had control over themselves. Police presented themselves at the home. They told their father that they had to speak to them. They did not ask. They entered the home without an invitation. Once father opened the door, they followed him inside. There was a lot of procedural incorrectness on the part of the police, and that caused my client to make incriminating, which is why this is more of an interrogation, a custodial interrogation, than an out of custody interrogation. If they're using these statements against my client, he does, need to be.
Well, I just want to step back because
Okay.
first of all, it has to be the issue of the custodial nature of this encounter, doesn't there?
Well, what made this, my client was not free to leave. The police positioned themselves based on the video between the door and him. He was not free to move about his home. They told him where to sit, where to speak to him, and they told him what to say.
So he wasn't free to leave.
He was not.
Both of his parents were there.
They were.
Were they also not free to leave?
They were not.
Did the police say that to them, or was that their feeling? I mean, I guess I'm trying to.
They did not say that to them, but they stood in between them in the door. There were 3 police officers. All were in the home during the session, if that's what we want to call it, until until it's deemed as other.
Okay, go ahead.
When they first arrived, they told their father, "We have to speak to your son." They did not ask if they could speak to the son. They did not make a request. And so the father, as seen in the video, and I'm happy to show those videos to the court, is standing in between the door and the police officer before they get in, with his hands up, bracing the door as to not let the police officers in, as they continue to say, "We have to speak to your son. We need to speak to your son." Afterward, father puts his hand down. He turns to go into the home, and the police officers follow him. He does not invite them in. They do not ask if they can come in until they are already inside of the house, starting the conversation. After that, the door is
So they just push past him? I guess I'm.
no, the door is open and they follow him, Your Honor. Would it be better if we just
Did the dad try to close the door?
not?
Okay, go ahead.
Once Officer Masterman is in the house, he says, "Oh, can we come in?" But at that point, Your Honor, he's already in. He's an officer. These are not, sophisticated people who have a lot of interaction with the police, who feel that they have the ability to say, "No, you can't come in," after the police officer has already entered the home.
So I'm assuming by that part of your argument, he didn't ask them to leave, right?
He did not.
All right, go ahead.
And so once the question and answer session begins, they tell my client, Emmanuel, who is a child at this time, to have a seat. He sits down, they pull out a chair, they tell him where to sit and what to begin to tell them what happened. My client has no information about what happened. He is a minor. And during the course of the interrogation, the parents do eventually step out of the room at my client's behest. Again, my client is 16 at this time. He has no understanding about what he's saying and the implications, criminal or otherwise, that it would have on him or his family. So for him to make that judgment and for the police officers to encourage it, which is what they did, it was grossly improper.
How did they encourage it?
Well, they said
Saying that they left at your client's behest.
the parents left at my parents said, "Okay, my parents can leave." And the police officers said, "Yeah, can you all leave?" This is his child. This is not someone who, is often operating without his parents. And I think I should bring to the court's attention.
Well, but then wouldn't it be incumbent, if that were the case, upon the parents to say, "No, we're not leaving"?
Yeah, it would be if the parents had English as a first language, have been in this country for a long period of
So
time.
that's the reason they didn't?
No. Your Honor, a lot of times when you have children of immigrants who do not know and understand the process,
I understand it,
they
Counsel.
rely on their parent. They rely on their children.
I understand that, but so they leave, so the parents leave.
Mhm. They step into another room with an officer,
Okay.
and they are followed by an officer, adding to the fact that they don't feel free. They don't leave the building. They don't leave their room. I mean, they leave the living room to go into a back room with an officer who goes with them, adding to the fact that they are.
Makes sense though.
But it's custodial in nature. It does make sense if you're in an in-custody interrogation.
No, it makes sense for officer safety. Right?
Yes, but it also adds to the custodial nature of the interrogation.
Okay.
If they're not free to move about their home without being followed by the.
Oh, you didn't say that. They were, an officer was viewing them while in the home. That's a whole different concept, Counsel, than to say that they're not free to leave or they have no freedom of movement.
They had no free, if they're going somewhere in their home and they're being trailed by an officer for his safety or otherwise, it adds to the custodial nature of the interrogation, of the entire presence of the police being there. That is my purpose.
I think then anytime the police show up, it's going to be custodial.
Then for that reason,
With that argument, it would be.
Well, and then for that reason, my client deserved to be read Miranda rights before he said anything that was remote.
Oh, no, I don't agree with your conclusion. I'm just saying, if that is indeed it, then every interaction with police is always going to be custodial, and we know that not to be true.
Yes, we do. But when a police officer controls your movements, stands between you and the door, comes in uninvited without a warrant, controlled my client's movement, controlled his father's movement, told him to sit here, told him to stand here. When those type of things are going on, it adds to the custodial nature.
Okay, go ahead.
When they're standing in between them and the door, when they're asking for statements that are incriminating, that is what makes it a custodial interrogation that Miranda should have been stated. And it wasn't from beginning to end. And they use that.
Interrogation, the fact that it's interrogation doesn't make it custodial.
No, but the fact that they are
just said though.
No, I'm sorry if I miscommunicated. What I'm saying is they're entering the home, refusing to allow the parents to leave, controlling the movements, and standing between them and the door is what makes it custodial in nature.
Okay, go ahead.
So those are the things that came in that were directed by Officer Masterman that prevented my client from leaving of his own free will and made my clients who not believe that they had any choice other than to have this conversation with the police that they did not want to have. Incriminating statements were made, and my client was not advised of his rights to remain silent.
The standard, though, isn't the reasonable recent immigrant, is it?
No.
The standard is a reasonable person.
Right.
So the police don't have to inquire, and the court doesn't necessarily look at that. I look at it on a reasonable person standard. Isn't that correct?
A reasonable person standard, yes. But we also have to have, there is also a level of empathy in their shoes.
It wouldn't matter. I could feel however I wanted. That's not the standard I'd have to rule on, though, counsel.
The court asked why something happened in this course. Why did the parents leave when their son told them to? And the reason for that is because there is a level of misunderstanding between the police and this child who was raised here, who fully understands whose English is not his, who is his first language, and his parents who are getting translated information through their son. So that is why that is an important facet that the court should consider.
Okay. Anything else?
Not at this time.
Ms. Willinger.
Thank you, Your Honor. If the main issue is whether he was in custody, I think that the people certainly do not believe that he was in custody and have a different viewpoint to how the police ended up in the defendant's home. Yes, they did encounter the defendant's father at the door. They told him what they needed to speak to his son about, and he let them into the house to speak to their son. In defense's motion, they frankly misstate some facts that are not. Defendant spoke to police in, you kind of enter the house and then it's the living room and the kitchen. Always in the living room. They never went back to the defendant's bedroom and secluded him there. It says in promotion on page 14 that he finds himself in his bedroom sitting on the bed. He was on a couch in the living room. At some point, the police do discuss with his father, like maybe it would be best if you weren't here. Because his father is getting emotional about the situation. And then the defendant point blank asks his dad to leave the room. Certainly, yes, he is a child by law, but told officers that he had already graduated high school, he was in college, he wanted to be an engineer. He certainly knew what police were doing there and what they were discussing with him, and he himself explicitly asked his father to leave. In addition, stating that the interrogation lasted 90 minutes is not correct. The total body cam time of police enter to exit is 60 minutes. And the time that the police officer asks if the father wants to leave, the defendant confirms, "Dad, can you leave the room?" And then from when family comes back in, it's maybe 20 minutes, 15 minutes. He was not in custody. He was in his own home. His family was present. He had ample opportunity to leave the room, move to a different room, get up. Of course, inherently, there is something intimidating about a police officer being present in your home, but ultimately, they didn't arrest him. They didn't take him in handcuffs at that point. They told him what likely the next steps were going to be and what was going to happen next. I think, though, from a perspective of custody, he was not in custody. He was not entitled to Miranda rights. And so from the people, do not think that a walk hearing on that, on statements made allegedly while in custody would be appropriate. If we're talking about voluntariness, the case law seems to show me that they would be entitled to a Walker hearing about the voluntariness of statements outside of being in custody. But I don't think that they make sufficient argument of the defendant was in custody in this case.
Anything else?
As far as my client being sophisticated enough to know why the police were there, they told him why he was there, why they were there. So that could be it. I don't know what that means. As far as where my client sleeps in the house, the living room is his bedroom. So, but that's neither here nor there. Officer Masterman pulls a chair and tells my client to sit down. The officers are standing between him and the door. A reasonable person would not believe that they were free to walk past the officers or go into the back of the house into a different room where officers followed his parents. That is the inherent intimidation factor of police being there is not why he's not free to leave. He was not free to leave because of their positioning, of their strategy, which they discussed prior to going in. Had no way of knowing that he was not leaving at that moment in cuffs. No one knew that. 4 officers coming into your house, but you're not leaving in cuffs. I'm actually surprised as to why he didn't leave in cuffs. So, Your Honor, I asked you to find the that they were in, that it was considered in custody. The voluntariness we agree on. He did make some statements that I do not think he voluntarily made, but I do ask that we have a Walker hearing to preclude those statements.
There's all of this reference to the body cam. Does either side have an objection to the court being able to view the body cam?
Not at all.
All right, well, here's what I'm gonna do, and if we can get a copy of that, I'll set a decision on whether or not to grant a Walker hearing in this matter for June 11th, 2026 I'll set it at 3 p.m. You actually may, but if not, then I'll give it from the bench. I will also, pursuant to the preliminary examination in this matter, the date may change, but the defense has asked for one. I'll set it for June 23rd, 2026 at 9 before me.
I'm so sorry, I'm gonna be out.
Yes, you're.
Probably gonna need a Monday then. You just, is that week?
That week, Your
That week? Do I have the 20? Okay. Well, the Monday, the 29th work for council.
That would work, Your Honor.
1 second, please. Unfortunately, that doesn't work, but I'm wide open the 30th.
I can, but I'd have, okay, I could do the 30th, but I'd have to do the afternoon of the 30th.
That's fine.
Will it work? All right. 2 p.m. Okay. So I'll set it for June 30th, 2026 at 2 before me. Okay.
Just for clarity, Your Honor, there are several responding officers, several body cams.
Yes.
I guess my suggestion would be that I provide Officer Masterman's body camera.
I agree.
Okay. And
So I just get one set, not redundant.
redundant, yeah.
Okay.
Officer Masterman was the leader, lieutenant. I'm sorry, don't have me misspeak his rank.
Yeah, it's just an officer.
Oh, he was just an officer. And so, but he seemed to be leading up the
But that,
investigation.
regardless of who's leading or doing whatever, that body cam, both parties believe will show me what I would do.
I mean,
Absolutely.
Okay.
that on a flash drive and provide it to the court on Thursday, that is. I just thought you.
That's okay. That's fine with me.
Okay.
All right.
All right.
Thank you.
All right. Thank you.
Thank you.
Did you say your name for the court? Via hello.
All right. But
State time said for preliminary exam, it wasn't previously adjourned because the people had the CAC held a center interview had just been completed the day before, and or defense counsel had time to review that. There was a bond violation filed by the deputy here based on statements made by the victim in the child access center interview that her mom had been contacting her either directly or through her grandma, which we staying with. The people admittedly do not have a victim present here today. I think it's going to have to be a situation where I have deputies physically go and get her along with her guardian who she's staying with. But I am going to ask for an adjournment for that purpose. I also think that an adjournment would behoove the defense in obtaining potentially a better offer, because my main focus here is seeing the defendant sober, seeing her as a sober parent, and any additional time sober is something I would consider an extending offer.
Johnny.
Yes, Your Honor. So we did adjourn the last preliminary examination, so both parties could review the recorded statement in which the child adamantly denies the strangulation, indicates that she made it up because she was mad at her mom and she had seen her mom being strangled before by her dad. And so that's where she came up with that. She also talked about people having rabies and a variety of other information that, you know, she's 7, so it's to be taken with a grain of salt. But my client adamantly denies the bond violation. She denies having contact with her since this case was pending. She denies the allegations against her in terms of any sort of assault, specifically strangulation, upon her child. So with that, she, we're here. We're prepared for the preliminary examination on the felony charges.
Yeah, may I respond?
Yes.
I mean, since defense counsel is making statements and claims about what the victim said in the CAC, I would like to respond to those in that, yes, she stated that her mom did not strangle her. I will admit that. But she said that she called the police because her mom had assaulted her in other ways, and because her mom was so intoxicated that she tripped and fell with the baby in her hands, causing potential injury to the baby. And that this child did not know how else to get help other than calling the police and telling them that something maybe worse happened to her because she needed help from her mom, who was too intoxicated to take care of her, too intoxicated to take care of the baby. I have continued and ongoing serious safety allegations. I'm not even going to touch the rabies comment because that was made in relation to something that she also alleged that she saw the defendant do. So I'm just asking that this case not be dismissed today. If Your Honor is inclined to dismiss it, I will have the deputy return and I will at least begin the preliminary exam with very, very basic information.
Your Honor, Matt, but she, I don't think it's for her to get from court, please, get on her medication.
Your Honor, again, my client denies the allegations. I'm pleased to report that she is sober and has been sober and is in treatment. So she's getting medication and she's in intensive outpatient treatment. She provided proof to my office. Regarding the adjournment request, obviously the court has the discretion to grant or deny the adjournment request. In this situation, it's unusual in that because she denied the initial charge, I don't think the people could reauthorize that charge. Obviously, they're free to interview her and to continue a remand as a misdemeanor. And I prepared Ms. Holloway for that, if that is to be the court's decision today.
What about your client saying she didn't have any contact with her?
So, Your Honor, I have not never had any contact with her, period. Your Honor, I have not had any contact with Reagan, period. I have not been talking with Reagan through me or anything of that nature. I haven't even saw my daughter, and it's killing me because I love my kids. I do admit to being influenced.
I just think it's inexplicable that this child in the CAC stated that she was told that she's the reason her mom is in jail.
Yeah.
How else would she find that out?
Because he can come home with me and talk to you, and I'm had to explain to her that's why. So
That is the part that frankly bothers me, because presumably the child would not have known.
Your Honor, the child did indicate she's living with multiple family members. Obviously, they're in the same family. So I don't know. Obviously, none of us know whether or not Ms. Holloway's had contact with her.
I hear you, but it seems just odd to me that the child says that and attributes that saying to a conversation that she's having with her mother. That takes a lot for a kid to do. I mean, if you look at those lines there, this child is very specific in terms of what she said.
May I submit an additional response? I'm not saying this is the case here because I don't know, but sometimes, I mean, Ms. Holloway was released after her arraignment, but she did spend some time in jail pre-arraignment. And again, I'm not saying this is what happened here, but sometimes she was actually released from the jail after her arraignment. So it is possible that she would have been on the phone with Reagan after she was arrested, before she was arraigned, before she was told not to have contact with her, and said something along those lines. Now, that I think at this moment, there is no specific information that it was a bond violation after she was released from jail. It could have been while she was in jail pre-arraignment, which wouldn't have been a bond violation. We would ask, if the court is inclined to grant the people's adjournment request, we would ask that her bond be continued. Again, there's no specific information that she's violated. I've been reaching out to her mom to try to talk to her this morning. Haven't been able to, but I'll continue to. And she's on these 2 tethers, GPS, Scram. There's been no violations of those since she's program. She's doing well. And so we would just ask that her bond be continued if the court isn't.
How would this child know or in some way fashion or attribute to her mother not to tell anyone that they've been talking?
Your Honor,
There's nothing.
again, I have had this conversation where the court has to, make a determination as to bond, presuming her innocent, but also to protect her daughter in the community. I will say, that she starts to go into all of the people she's been living with in the family who's been talking to her about the situation. At one point, she just leaves the interview room after mentioning, yeah, my uncle lives with me, and then she leaves, and then she comes back talking about, I don't know which family members are talking to her. I don't know who is saying what. I understand that people are making that Ms. Holloway is communicating with her. She's denying the allegation. She's simply asking that if the court is inclined to set this for bond violation hearing, or continue the preliminary examination or adjourn it, her bond be continued so she can continue her treatment, which at the end of the day is her goal is to stay sober, continue treatment. And this is she's known that she has faced going to jail all morning. I mean, she's been here. We've been talking about this all morning, and she understands how serious this is. We've talked again and again about the court orders. And even if this case was reduced to a misdemeanor, remanded, dismissed, I mean, the prosecutor and the court could still sentence her on contempt, right? On a bond violation. She understands that. She has never been in trouble before. She's trying to do right. She's trying to prove her compliance. And I know she's eager to speak up for herself. I've advised her to remain silent, but I know she's eager to tell the court that she wants to stay sober and stay in treatment so she can earn the privilege of reuniting with her children. I know she's working with the CPS caseworker as well, and complying with their plan moving forward. And I don't know if they have any additional information about this. I mean, last time I spoke with them was more than a week ago, so I don't know what information they have within the last week, but that could also shed some light if they were to have any additional information.
I did speak with this docket in that obviously was candid with her that my victim is not here today. And I wasn't opposed to, despite the allegation of contact, having the defendant's bond continued so that she can continue in this program and attempt to remain sober to be able to reunite with her children. I will say of note in listening to her jail calls when she was remanded on the past bond violation, it does appear she has a lot of support in her community, but a lot of recognition that she has a major alcohol problem, and if she wants to be around her kids, she needs to address that. So that was kind of my statement to Ms. Yagi that I would be okay with her bond continuing. Would give me another opportunity to try to get victim here so that we could potentially resolve this and get defendant, I think, the treatment that she ultimately very badly needs.
Normally, if the parties are in agreement on the bond, I would follow along with that without a lot of hesitation. Ms. Holloway, I'm just gonna tell you, I've got a lot of concerns about you.
I have to say you heard.
Because every time when I release you the one time, you violate.
Your Honor, I had just.
You're back here and when I released you on the 19th, I think it was. And then have this indicating that you're violating the bond. I have real serious concerns as to whether or not you take what this court says. So if you want to tell me why I think I can trust you not to have communication, then here's your opportunity to tell me. But because I'll be honest with you, right now, I may be inclined to just send you.
Well, Your Honor, one potential additional assurance could be following up with the guardian. She signed the power of attorney over to her mother, who's, watching the child. And I don't know if the people have had any contact with her. I've played phone tag with her. I haven't actually spoken with her, but my client indicates that she, just like her godfather and I think her godsister's here, but they are like very strict and they take this court extremely seriously. And even if she hasn't proven her trust to this court, they are additional assurances that she will not violate. She will not have any mechanism from which to violate. Again, I'm not trying to say she would even violate, but even if she wanted to, she's saying that they would not let her because they are taking this very seriously and they want the end goal of reunification. I mean, this is a case where the interview seemed very clear that this is a case for reunification. And so the only way she could do that is by proving that she will comply. And understandably, the court has concerns. At this point, I would ask the court not to make a decision as to bond, perhaps set this for bond violation hearing. And maybe I could even subpoena her mom to come to court. Like if it's helpful to shed light onto where this contact is coming from, whether it was pre-arraignment or post-arraignment or when. But that could be an additional assurance that the court would have is the people in her life that are taking this very seriously and that have the end goal in mind for her to reunify. And the only way to do that is to comply with the court.
For the adjourned preliminary exam date, does the 16th work for the parties?
Yes, Your Honor. June 16th.
Will that be enough time to?
Yes, sir, that works.
What I'm going to do in this case is I'm going to adjourn a preliminary examination to June 16th, 2020 before me. Of rights, Ms. Holloway. I really should lock you up today. I should do that for the protection of the integrity of this whole process, because I think you run right up to the line, you jump over that line, and you don't think anybody's going to do anything. It's like with your last violation request, they're telling you to get out of the area, you don't do it. Think at that time you were still drinking, because then when they got you, they said, well, take a PBT, which quite frankly, in this court's mind would have helped you. You didn't take that. And frankly, my view is the reason you didn't take it is because you knew you'd been drinking. But you knew your bond condition was that you weren't supposed to be consuming alcohol. Do I, as we sit here at this moment, believe that you had improper communication with her, with your daughter? Absolutely, I do. Because nothing you say, at least at this point, I have any reason to believe. Told you when I let you out the last time, you're gonna have to play by the rules, and if I find out, and if I'm sure you violated those rules, you won't be coming out of that jail. There's gonna be nothing anybody's gonna be saying to me that may let you out. I'm gonna let the people, you have to, I guess, I'm gonna let you go today. Over my goodness knows I really do not want to. I'm gonna give you that same admonition that I gave you at the last hearing. Something comes back to me that you violated to any extent, any of your bond conditions, I'm just gonna lock you up. I really should be locking you up pending a hearing in this case, and if it hadn't been for what the people said and what the ultimate goal here is, I would. So you can thank all them for that, because my gut was telling me I should just lock you up. So you figure out which way you want to do it. I'm going to set a bond violation here for the same time as the preliminary examination. Come forth to me with additional evidence, or any evidence which I'm sure I'll make a decision at that time. May lock you up on that date. Just not doing it today. Quite frankly, I have little belief that you will make it to that date. This point, your bond will continue.
Your Honor.
I should have also said, although she's left, for purposes of the record, I checked with community corrections. Because quite frankly, like I said, I don't believe anything that she says. And I checked with community corrections, just make sure there weren't any interim violations of her alcohol. They reported to me that at this point, there are none.
Thanks. Ashley Stevens. She is here. 25 CR 1682. You're charged with state jail felony of burglary of a building. Do you have any prior convictions other than? She gonna case coming? I thought this long was like, great. So she two cases. I think you have as well. Well, yeah, that's all this thing. Judge, if you don't mind, I didn't know if she had another case coming. I knew about this burglary of the building, but apparently Ms. Moore saying she has another case coming. I didn't realize about that one. What is it? What's the new case?
It's an ag assault with a weapon.
Oh, that's a second degree felony.
Yes, sir.
This one's burglary of a building, a state jail felony.
And that took forever to indict. But it's done. Took almost 2 years. So when is that coming down? Do you know?
Judge, I have it,
Do you have a proper cause affidavit? I don't know. Sure. When did that get indicted?
my indictment judge doesn't have the date stamp. I can look at my computer here in a second. Here is the.
It's just happened not long ago. Right. You're accused of stabbing someone in the chest, you know that. Okay. Alright, that's gonna end up being a second-degree felony. Here's the problem, is that you were posted a bond at $5,000 in January on this burglary of a building. Then this new event happens on April 17th of this year after you had posted a bond. So this is going to be a high bond when this happens, when this indictment comes down. Because you currently on a bond on this case, and now that's enhanced to an aggravated case now. That's aggravated assault.
Judge, it looks like that was indicted May 13th of this year.
Yeah. Is there a bond set already? That would just been last week.
She
And
lost it too.
Is there a warrant out for him?
It sounds like she's already bonded out for.
She made the bond on.
What was it?
2,000,
What?
200,000.
200,000, what she said. That's pretty high. Oh, wow. She says 200,000.
Do you retain?
No.
Oh, wait a second. Hold the phone. You can afford a $200,000 bond but the taxpayers are going to pay for your lawyer? No way, not on my watch.
No, it was 400 to get me out.
Yeah, I don't care. Somebody, you have access to money. He's being appointed and he's being paid by the taxpayers of this county. You probably don't care. But 250,000 people on my watch, I take care of them. And you're interrupting, Miss Rudeness. Only one of us can speak at a time. When you speak over, the court reporter can't take everything down. I mean, you've got one crime here. Now you've got an aggravated assault, stabbing someone in the chest, which is a second-degree felony. And you want to compound this with letting the people? No way. You hire your own lawyer. You can come up with $200,000 for a bond. You get your own lawyer. Or we'll let somebody, if you can't afford that, we'll revoke your bond and then you can sit it out and then I'll have him appointed. But no, you get your own lawyer.
Here's the stuff.
That's almost laughable. But I know what's happening. It's the game's being played. It's other people's money. 250,000 taxpayers paying for your mess. And that's just not fair. They tell me that. It's just not fair. And then that's what we're supposed to stand for, fairness. You, meanwhile, commit one crime after another. So no, you get your own lawyer. I expect. Or get your bond refunded and sit it out and then pay for a lawyer through that. But you have access to money. No. No. This isn't $200,000. It's $20,000. It was $20,000. Why'd you say $200,000?
Trying to correct myself.
nonetheless, where are you getting $20,000 when we have a court-appointed lawyer?
I got out at $400 from Al Reed, so they wanted 2,000. Al Reed took 100.
Yeah, I know, but it's $20,000 bond. You need to. Does she have an indigent? I mean, we're treating her like an indigent. Did you fill out an indigent form?
We love Judge.
There's something there.
Yeah.
Let me see.
Kind of, Judge. Let me
Let me print that out.
All on out.
The way this is done sometimes, it slips through. And it's halfway done, if I may use the proper terminology, because it's an affidavit that's supposed to be signed and it's supposed to be thorough on what your income and expenses are so that the taxpayers don't get stuck paying for your mess. And I'm one of them. Shame on you for picking this thing up again after you already had a crime that you're dealing with. Shame on you. But that's why it gets more expensive and more serious each time. Thank you. Where'd you get the money for the bond? Because this shows you make zero. You make zero. Where did you get the bond money?
Yeah.
Who?
My mother, friend.
Your other people are paying for your messes now? Is that what this amounts to? Oh. Because this shows zero income. Zero. Is that right? You have zero income?
Mm-hmm.
How do you exist except off others? How do you exist? I mean, how do you pay for things? You've got shelter, you've got food, you've got clothing, who's paying for that? Others? Have you ever thought about becoming independent and living on your own with your own? Making, self-sufficiency? Or just you exist off of others?
I'm stay at home mother.
You've got a child.
I'm two.
Aggravated assault now? Were you thinking of the child before you stabbed the guy in the chest?
Yeah.
Really? No. We're going to review this in 4 weeks. I think it'll be this thing enough. Let me just say, you're free falling. You're acting about as irresponsible as a human can be, and you've got responsibilities, not only to yourself, but you've got a child at home, and you just picked up. You go from one crime to a more serious crime, and other people are paying you. Right? Parents, but you got responsibilities, and from parents, it's supposed to be a role model. And let me tell you, your child can't learn anything from you. You compound your errors by just making it worse. Irresponsible. I'll remind you about it next time, because I know how you roll your eyes. This is boring for you, but others are paying for your messes. You're making messes, you got responsibilities, and 250,000 people are paying for your mess for him, because you can't figure out how to do the right thing and make the right choices. And you got a child that you're supposed to be role model, making a good example, but you have been an absolute failure. All right, get a reset. All right, then I got the lady. Come bring her out. And who is that? First,
Phone number, under your name. Like, do you have first? Do you have first as well? Did she do first as well?
Okay, Elisa Annette Percy, that's you. All right, 25 CR 1867. And let's start this thing from the beginning. You are charged with the state jail felony of burglary of a building, which carries with it up to 2 years in the state jail. So it's a felony. It's the least serious of felonies, but it's still a felony. Do you understand, ma'am, what you're charged with and the punishment range that could be applicable? Okay. Do you have a lawyer? Do you need one? Yes. Are you able to hire one? Have you filled out an indigent form? Get her to fill that out. Kendall, if you'd be so kind, fill that out and make sure everything is true and correct. Okay? Let me ask you this. Are you married, ma'am, or are you single lady? Do you have any dependents? Children?
I have two.
2 children? Okay. And are you responsible for their well-being, or does the father help in any way?
Yeah, he's present, but I have to get them.
Okay. Please fill that out then, and I'll look at it and I'll review it. If I deem that it is appropriate, an attorney will be appointed to represent you immediately, okay? All right. Do you have any other pending cases in any other jurisdiction? Okay. All right, just fill that out, please. Thank you. Hey, let me talk to the lawyers up here. Yeah, Miss Percy, come on up for a second. I'm looking at this indigent affidavit.
No.
And so this is between child support and your food stamps, that's your income, right?
Yes.
Okay, and it's 980. I'm reading that's 280 a month and 980, right?
Just started.
But you just started.
Yeah.
Okay. How much is your pay going to be at that other?
11.25. Like
Okay.
11 plus.
Right. And here on monthly expenses, I've got 400, 700 and 120. You put 1320, but that's not, that wouldn't be right. It would be 1220, not 1320. So I'm going to correct that because it's an affidavit here. You don't know. And so I'm going to, you're going to need to update me when you get your income on this new job, okay? Because currently you meet the eligibility requirements for an appointed lawyer right now. It depends on, I'm not sure how much they're going to pay you, but we need to know. If they pay you a lot of money, then great for you, but you're going to have to then get your own lawyer.
I want to be working 31 hours. That's how much our insurance.
How much?
1 hour a week. That's how much our insurance will cover.
Well, how much is it an hour?
I think 11.25.
That's $20,000. That ends up being 20,000. That's still low. That's still low enough to get you a current lawyer. Well, you know what you got in you right now. We tested you. We just drug tested you. You know what you've got. You've got methamphetamine in your system.
Yeah.
You've got meth and amphetamine in your system. What's your bond?
15,000.
If bond is revoked and it's doubled to $30,000, plus you must have a drug patch as a condition of bond. You can't come in with methamphetamine in your system.
I think that's.
It tested positive for meth. We just tested you and you tested positive. You know better than everybody else. And everybody denies it. And then they go, yeah, okay, it tests. You're right. That's what happens. But these tests are correct. Fix this. You've got responsibilities that you're trying to handle. I know you've got a job, you got a family, and that's great because you're obviously not lazy. and you're trying to get something, but this intercepts everything when you're not clear-headed and you're getting drugs. Fix that. Only you can do that. Yes, ma'am.
I'm going through. No.
Well, no, but you tested positive today for it. Do whatever it is you need, and I'll cut some slack for you. I really, but right now, this is what's normal. You get doubled on your bond, then you have to have a drug patch, but you got to test negative. Yes, ma'am. I know, that's what happened. You can't, I'm not letting you out with that methamphetamine in your system. Plus, it's technically a crime, but you got.
Well, Your Honor, so what she's taking is Adipex, which is phentermine, and it does say it pops positive for amphetamines, and it can sometimes pop a false positive for methamphetamines. She does claim that she has a prescription, and she said she can give it to us, but it's your call.
What's the position of the probation office on that if they bring you a prescription?
So usually if they have prescriptions for stuff, that's usually what we ask for, is if they have a prescription for medication that will pop.
Who gave you the prescription?
It's a doctor and provider. I don't know her name right now, but it's Dr. Boo, doctor. I don't know, I have to Google it, but it's a doctor and provider.
What's the,
She has a.
All right, Eric Woods Johnson, 26B710716. All right, good morning. We're gonna have to get the prosecutor in here. All right, so I'm back on record, and I'm Eric Woods Johnson, 26B710716. I'm gonna ask everybody to state their name again, please, for the record. Stand up, Mr. Woods Johnson. Tell me your name.
Eric Woods Johnson.
And Ms. Tucker Davis.
May it please the sound of court, Don Tucker Davis, P5, Don Woods Johnson.
Why don't you move over there, Mr. Woods Johnson? Ms. Alloway, your name? We have a potential bond violation. This is going to be a waiver, correct?
That is correct.
I'll take the waiver. We'll address bond before I sign the bind over certificate. Sir, you understand what your lawyer is telling me?
Yes, Judge.
Your lawyers, you have the right to a preliminary examination, but your lawyer is telling me that you're going to waive your right to an exam. There's two counts. Count one, felonious assault, a 4-year felony. Count two, domestic violence, for which you don't have the right to an exam because that's a 93-day misdemeanor. But on the felonious assault, you do have the right to a preliminary exam. And at that exam, the people would have to show that the crime was committed and that you were the one who probably committed the crime. By waiving your right to an exam, you will automatically be waiving that requirement. You will be bound over for further proceedings to the Wayne County Circuit Court. Do you understand that?
Yes, sir.
And did you sign, read, and understand this document entitled bind over after preliminary exam / felony?
Yes, sir.
Anybody force you to give up your right to an exam?
No.
You still to do that?
Yes, sir.
Waivers accepted. I'm going to bind you over, but I'm not going to sign the bind over certificate just yet. But your court date will be on June the 9th in the Wayne County Circuit Court. Now, let's talk about the bond violation. There's a complaint of violation of conditional release that caused him, I don't know if they arrested him. Did they arrest him, Ms.
On the date of this incident or this case in question?
On the complaint of violation of conditional release?
No.
So you need
That
to,
was sent in the last Tuesday morning to the court. If you recall, that was when myself and Ms. Tucker Davis received it.
And Mr. Wood.
did I address that already?
Yes, and so we set this court date for the hearing.
Well, complaint of violation of conditional release, and I'm not asking you to look at that. But when when there's a complaint of violation of conditional release, it permits them to take him right into custody. In other words, if the police were called and by the victim and were told that there's a violation of the no contact provision, and they went out to the house because the defendant's still there, they can fill out this form and they can immediately take him into custody. That was not the case here. So the detective really needs to come and swear to an oath and explain what he has. And then the judge, whether it's me or Judge Hessen, are going to get to determine whether or not there's probable cause to believe that the defendant violated the bond condition, or at least by a preponderance of the evidence. So I'm not going to make an issue of it, but if this form, complaint of violation of conditional release, really should only be utilized when they're taking the defendant into custody because they have the basis to believe from their own eyes that he violated the bond. Otherwise, they should come in and do essentially a signing on record and swear under oath as to what happened. Okay? Am I making sense?
So if swearing under oath on the record is the alternative, if they did not take them into custody?
Correct. In this case, it appears to me she got the victim showed them text messages, right?
Correct.
So they wouldn't have seen him. So now they really should come in and what they could do it on record on Zoom, but they can't. It's fine the way he did it, but they're using the wrong form. They should be testifying in a case like this, as opposed to filling out this complaint of violation of conditional release, which enables them to take the defendant into custody. That being said, I'm going to read it.
Your Honor, the complainant is here. I did, we're prepared to put her on the record. There have been other allegations that she has told me about that I would consider intimidation and harassment that I know the court should.
Is she in here now? Bring her in.
Would you like to begin a hearing then, or we call her in?
Yeah.
Okay, so people will call Alicia Calvin. I will go. The advocate is here. I'll open up.
You guys can have a seat. Detective Vesprini, are you on this Bensick case?
Yes, Your Honor.
If you want to just bear with me a few minutes, okay? And I'll call it as soon as I'm done with this little hearing.
Okay, no worries.
All right, ma'am, come on up here. Whoever Ms. Calvin is. You can go right there to no, right behind you. Right there. I'm just going to ask you to raise your stage.
With the microphone.
That's a microphone. There you go. It doesn't look like one. I don't blame you for not realizing it's one. Tell me your name if you would.
Asia Calvin.
All right, I'm going to ask you to raise your right hand. You solemnly swear right hand. Solemnly your right hand. That's your left hand. Right. It's okay. It's all right. I do that all the time. You solemnly swear or affirm the testimony you'll give in these proceedings will be the whole true self you got.
Yeah.
Don't be nervous. What kind of contact did Mr. Woods Johnson have with you on May the 15th?
He didn't have any contact with me. I returned back to the residence on Mother's Day. My father passed, and I left the residence in a hurry. I left all my stuff behind. And I returned on that day, and when I returned, he was in the home sleep.
Well, on May the 19th, I told him he may return to the property at 23652 Matt's Drive, Brownstown, after 6:30 p.m. I think you were still in there at the time. You don't own the residence, but he did this on May the 15th. Is that true?
Yeah, this is beforehand.
Well, counsel, how can this? Hang on one second. Let me check something. I did not do the initial arraignment. It was done out county, I believe. Was there a no contact provision?
Yes.
Yeah.
I was told that he wasn't going to return to the home, so that's why I left my things. I had packed them up. I had put them by the door. I had turned off all the lights, and I had left. It definitely looked like I was leaving. My things were packed when he got rid of them.
Okay, so May the 15th is the date that this occurred, that he came back to the residence? Is that true or false?
I'm not sure the actual day right now.
Your Honor, if you, I can show her,
I have the text message correspondence from when I was in the house. I have audio from when I had came to the house prior to that.
When were the text messages between the two of you?
It was the morning right after I had left.
So you gotta tell me, you gotta be more specific. I have to know dates. What date did you leave there?
Can I get my phone so I can?
I think I would love it as well.
Yes, in my minutes.
Your, the court would prefer, we could have it on the stand and, I could ask her.
That's fine. Have a seat over here, ma'am. You're still under oath. Go ahead, Ms. Oliver.
Could you please state your name for the record?
Angel Calvin, sweet.
So, Miss Calvin. Did something on May 8th bring you to court today? You have to say yes.
Oh, yes.
Do you know somebody by the name of Eric West Johnson?
Yeah.
Do you see him in the courtroom today?
Yes.
Could you point to him and tell him the color of his shirt?
What?
Your Honor, please let the record reflect that the witness has identified the defendant.
Record should so reflect.
Asia, are you aware that there is a case open today involving yourself and Eric West Johnson?
Yes.
And, the case was initiated because of an incident that happened on May 8th, 2026. Do you remember that?
Yes.
And following, well, let me ask you that, on that day, did police arrive?
Yes.
And was he arrested that day? Was the defendant arrested that day?
Yes.
You gotta keep your voice up for us, okay?
Following that, were you aware of any type of order made by a court that did not allow the defendant to have contact?
We're speaking in reference to the assault,
No, following the incident in question where the defendant was arrested, were you made aware of any order that did not allow him to have contact?
the police removed him from the residence and told him to not return.
And are you aware of any order that was put in place that?
By a judge. You're shaking your head no?
No.
Are you aware of something called a no contact order?
No, there was no contact order.
Is that to your knowledge?
Yeah.
Okay. But do you recall the police telling you not to return the name?
Yes.
Your Honor, at this time, I would just like the court to take notice that there was no contact.
All you have to find out, listen, did he have any contact with you on or after May the 10th of 2026, either by way of phone call, texting you, emailing you, coming to your home, coming to your place of employment or otherwise?
No, I seen him the day at the house when I came.
You know, what day was that, ma'am?
I'm having a hard time here.
Okay, listen to me. I want you to listen. Just listen to me.
So I need to be able to see my phone to understand which one we're talking about.
Okay.
Over that entire week, the police had been to our home like 5-6 times.
And if I may apologize.
Yes, the incident occurred on May 8th, right?
With the knife, or are we speaking?
The case that we're here on today, ma'am, look at me, please. Just look at me. The case that we're here on evolves from a May 8th incident of 2026. You're aware of that?
Yes.
Where he's charged with felonious assault and domestic.
Yes.
He was arraigned on the charge on May the 10th of 2026 by a judge out counting.
Okay.
The judge laid out conditions like you can't have contact. Wait, just listen. You can't have contact. You can't go to her house. You can't go to the Matt's Drive house. So I want to just talk about anything that happened on or after the date of that order of May the 10th.
Okay.
Did he have any contact with you on May the 10th in the evening or thereafter up until today's date of May the 26th?
Yes, when I went to the residence before. When I went to the residence before the court date we had before this, he was at the residence.
What day was that? You can look at your text. You need to look at your phone to refresh your recollection?
Yes.
Okay, go ahead and look at your phone.
It was May 15th.
Okay, what happened on May 15th?
May 15th around 2:00. 2 a.m. Yeah, I went to the residence to retrieve the things that I packed and left by the door. When I left on Mother's Day when my father passed away. When I got to the house, I opened the door and I had came in. Prior to this, Eric had took all the doorknobs and the locks. He took all the doorknobs off all the doors except for one. He took the locks off the doors.
So you appeared there at 2 a.m. to retrieve personal property? Wait a minute, listen to me. Listen. On May the 15th, you returned there at 2 a.m. to retrieve personal property. And he was in the residence. And there was an order for the record from Judge, it looks like, or Magistrate Boyer, I don't know what court he's out of, but at any rate, it was signed May the 10th. Do not enter the following described premises, 23652 Mats Drive, Brownstown, and do not have any contact with AJ Calvin. Why were you returning there at 2 a.m. though?
Because prior to this, like the reason why I was living with him is because I told him my car almost died. I don't have a vehicle, so I have to go by, whoever that's around me who has a vehicle that's able to take.
Did he have any other contact with you after May the 10th up to today's date, other than on May the 15th?
No.
Your Honor, if I may, continue. Did he text you at all prior or after that day?
After what day?
After May 15th?
He texted me on May 15th.
What does the text say?
He sent me $103 and said, "This is all I have. My Uber account is gone."
And for the record, this text screenshot was shared with defense.
This text happened while I was in the house.
And so following that day, did you leave that home was it in Brownstown Township?
Yeah.
And
Can I ask a question? I don't want to take the wind out of your sails here. Did anything else occur? Any other texts? Any other time he called you, saw you, emailed you, phoned you, whatever you want to call it, or came to your house, or came to your work, or came any place else after May the 10th, other than the contact you had on the 15th and the text message that you just described that he sent you?
Eric called CPS on me.
All right, well, that's a different issue. Did he?
He hasn't had direct contact with me, but he called CPS on me. And then after that, the police had showed up to my house with disturbing calls about my son. Which was also here in the report. I had lied to Eric and told him that my son was in truancy. My son is a pre-K student. He's part of GSRB.
Any other contact you had with him?
He told them that my son was in truancy, not going to school, that I was doing drugs with him.
Okay, I get it, but he made a complaint with CPS, right?
Yeah.
He didn't say this directly to you, any of this, right?
No.
Okay, I don't consider that to be a bond violation.
that is considered indirect contact and is a form of intimidation and harassment. And Your Honor, for the record, her testimony is completed effectively. Would you still like to have her testify or invite findings to be an argument?
Well, I think the defense gets an opportunity to cross her.
So
Wanna-
they're not, I apologize for interrupting.
It's okay.
I'm just going to ask a couple more questions, Your Honor.
Take your time.
Currently, what city are you living in?
I stay in Lansing.
To your knowledge, are you aware of if the defendant knows where you live?
Yes.
How?
He took my lease.
When you
And
say lease, what do you mean?
so when I smacked that pole and totaled my car, Eric came and got me from the hospital. And I signed my lease. After that, he took me to sign my lease. My
Let me stop
complex is
there.
huge.
Do you need a leasing agreement?
Yeah,
Okay, so to your knowledge, did he ever have possession of that? To your knowledge?
yeah, he told me that he took it.
And did you receive a visit from CPS following May 15th?
Yes, after the court date, a few days after that, CPS showed up at my.
Did you ever have any type of police contact at this point as well?
No. Oh, yeah.
Did the
Yeah.
police arrive to your house?
They came to my house like 3 or 4 times that evening after CPS showed up with disturbing allegations.
Now, to your knowledge, if you recall, do you know why the police showed up?
The police told me that there was disturbing allegations that I was consuming marijuana with my son.
And currently, is that an issue for your leasing agreement, if you're aware?
So, yeah, before I moved into this leasing, the place that I moved into, they were under other management. They've had instances where someone's team.
Who's on the lease?
I just.
So is it?
Wait a minute, wait. I think I heard something differently last week, did I not? Who is on, were you leasing this with this gentleman, this property?
No, I was living there with him.
Your Honor.
Wait a minute.
I think there's some confusion.
Yeah, there's a lot of confusion.
So there's the home in question that they were initially both living in, and she has now moved out, and she's in a home in Lansing.
Okay,
And so the lease agreement that she's speaking about is for this new home in Lansing.
okay, why are we talking about the new home in Lansing and our lease agreement?
Your Honor, because of the indirect contact that was made by the police and CPS.
Okay, but he made an allegation with CPS, right? Oh.
To our knowledge.
Now, I don't know that this, now he might have other issues, but I don't know that that's gonna amount to a violation of the no contact. Is the CPS investigation closed?
No.
Well, wait a minute, wait. I don't want us to talk about the CPS investigation. Under no circumstance would I suggest or order somebody not to make a complaint with CPS if valid. And the investigation is still ongoing, but here's the simple fact. He violated the no contact provision by going back there on May the 15th when magistrate or Judge Boyer told him not to. And he violated the no contact provision by texting this young lady on the date that she indicated. We don't need to talk about CPS.
I have no further questions.
Do you have questions of her?
Yes, please. When the May 15th, and you received a text from Mr. Rich Johnson, did you contact him previous to that?
Did I call Eric prior to that?
Yes.
No, I think I called him after.
And Your Honor, if I showed you something, would it refresh your memory?
What is that?
This is a message.
Text message?
Yeah, it's a phone call.
Okay, you can approach and show. Okay.
Thank you. This is refresh your memory.
Take a look at that real carefully.
That's my number. So the call happened before that, I did. Oh, no, I think that's the 15th. That might be the day.
And this is your telephone number? Yes.
Yeah.
Okay, and this is dated on May 15th?
Yes.
And the time says 7:46 PM?
Yes.
Okay.
What time did he text you? Before or after that?
That was I called them, so it was the same day after that I called him.
And he already texted you before you called him.
Yeah, he texted me while I was there at the house.
And then you called him after that.
Yes.
Good, go ahead.
You're saying he texted you before he made his phone call?
Oh.
Okay. And the text that you were talking, the only text you received earlier was the one from him sending you money, correct?
Yes.
Okay. And when you called him, did you ask him for money?
Yes.
Okay. Now, the lease that you're talking about is in Lansing. How long have you lived in Lansing?
I lived in Lansing for the past, I think, 3 years.
Okay. So, and your lease was on May 8th of 2026, your name's still on a lease in Lansing. Right?
I think it was before then. When I told my car, he picked me up from the hospital, he took me to sign my lease. And then the lease was in the car and I didn't see it again after that.
But on May 8th of 2026, you had your own residence, correct?
Yes.
In Lansing.
Yes.
And
Had you ever lived with him or you just had a dating
I
relationship?
we were living together after I totaled my vehicle.
And when did you total your vehicle?
I totaled my vehicle on.
Just roughly what month, man?
Uh, I'm sorry, a lot has happened since then.
Was it more than 2 months ago that you totaled your
Yeah,
car?
it's been like
Then we don't need to talk about it. If you were living with him,
March 22nd.
okay, all right. And you were living with him until then?
Yeah,
Until March 22nd of this,
oh no, March 22nd, I started like living with.
but you still had your place in Lansing?
No. I signed my lease March
All right,
20. I was released from the hospital and he took me to sign my lease. I was staying in a hotel prior to that, and then I hit that pole. I was coming out there to see him, and I had hit the pole, and he had came and got me, and we were staying with each other ever since.
okay, good.
And Ms. Calvin, your name is not on the lease, at the residence that in question on this case, correct?
No, it's not.
On Mance Drive, your name's not on the lease, correct?
And you actually, when they arrested, Mr. Woods Johnson, you actually received a ticket that day, is that correct?
No, I didn't.
The police didn't talk to you about a ticket?
They didn't give me a ticket because Eric.
No, yes or no, did they give you a ticket for?
Your Honor, I'm
No.
gonna object to this question. I don't think it's relevant when she received a ticket for this car accident.
Yeah, it's not.
It's not.
I'll sustain it.
Trespassing. I was trespassed from the residence when they arrested me.
Okay, okay. I don't think we need to hear any more. I get what you just said.
Right, and I'm gonna go back to one more question. You said that on May 15th, you received a text message from Mr. Woods Johnson. Before the one that you received at 2 later in the evening, correct? Because you called him and asked him for money?
No, so when I went into the residence and he was in there, sleep on the couch and all of my things were gone. I said, where are my things? He said that all of my things were gone.
You have a text message from May 15th before 7:46 p.m. from, no. Thank you. No further questions.
So you said before that you called him after he texted you, correct?
Yeah, that call that he had was after he texted me.
And it seems like it just contradicted your testimony. What time is that? 7:40?
7:46, Your Honor.
The text messages that he sent me, the money happened at 2 a.m. That happened at 7 in the evening that same day.
I see. Okay.
And just to clarify, you do not have a text message before 7:46 p.m. on May 15th.
I do the morning text message when he sent me the money.
On the 15th. That's it.
On the 15th. That's what it is. And then I made that call around 7 o'clock that same day.
It's in the
Evening,
so that was like
hours later.
12, 17 hours later, right?
No, because it happened, I seen him at the house at 2 a.m. and then I called him in the evening time at 7. Because when I was in the home and I asked him where my things were and didn't get rid of my things, he told me that he went through them and took the things that he wanted to his mother's house and he got rid of all the other things. I called him at 7.
Okay, wait, there's no questions though right now. Just wait 1 second.
Is on there. When you were living with Mr. Woods Johnson, it was his residence, correct? Were you contributing to that residence?
Wait a minute, wait, you gotta answer out loud. When we're living with him, it was his residence, right? And were you contributing to financially toward food or anything else? You were?
Yes. Were you working at the time?
No.
So when you called at 7:46 on May 15, 2026, did you ask Mr. Johnson for money?
Yeah, I asked him to
Okay,
return
thank
money.
you. Thank you.
Any redirect?
Yeah. The last thing was that you asked him to return the money. What do you mean by that?
So basically, Eric. So when me and Eric were getting into it, a police officer, the day that he punched me, told him that he could, because we lived there together, and because I had established residency, that he could destroy my things. He can take my things and do what he wanted with my things, and there was nothing that I can do about it. That it was a quote unquote civil matter.
Let me stop there. You said return the money. What did you mean by that?
He took my lease and my son's money was in that envelope. It was in the manila envelope with my lease.
And so I had asked about.
Your Honor, objection. She's talking about things that are relevant to this case.
Yeah, why are we talking?
Your Honor, she had said the reason why she asked you for money in that phone call. I can move on.
Thank you.
And so you indicated you were living at the Matt's Drive residence. Is that correct?
Yes.
And did you start living there somewhere around between March 22nd and March 26th?
Yeah.
And did you sleep there?
Yes.
Like almost at least every night following that day?
Yes.
And did you have clothing there?
Yes.
Did you and your son live there together with the defendant? And did you indicate that you moved out sometime around Mother's Day in May of 2026?
I didn't move out. I packed all of my things and put them by the door because I was under the impression that he was not allowed to return to the house but one time with the police escort. So when I packed my things and put them by the door, I didn't think the police were going to allow him to take them when he returned. I didn't know he was just going to come back when he was released.
I have no further questions, Trevor.
Anything else?
I do have one.
Just
One question, there's not a date on here. Did you talked about a black eye, correct?
Yeah.
And did you make a report to the Brownstown Police Station with that?
Yes.
Your Honor, I would ask that, there's information here I would like to call Detective Patard.
For what?
Because at that time, I think that
Oh, is this germane to the bond violation?
you heard yourself on the air. The Detective Patard said that Mr. Wicks Johnson was the complainant on the case. When she told him she had a black eye, and she went ahead and he pulled the file, and she was the defendant on the case.
Your Honor, I'm going to object to this line of questioning just on the basis that it's not relevant. It's about fire report, and this is only a bond violation, right?
Why are we talking about that? This relates to a bond violation that occurred on or after May the 10th.
But she did state on the record, it was brought up by the complainant herself, and which is the next two on here was broken with her character.
Relevancy?
Ma'am, this is not for you to decide. I guess I'm not understanding. Can you enlighten me?
It's to her,
Well, I know, but
the truth of her testimony, on that part, where there's a discrepancy in the truth of her testimony.
Because you're saying that Detective Patard will corroborate your client's version and that she was not hurt?
That's what, stated in the prior report, so I would have to go and read into that. But the complainant herself is the one that said that Mr. Woods Johnson punched her in the eye. I would like that either stricken because there's no evidence of that.
I have audio.
Wait a minute. Wait, whoa, whoa. You can't respond. This, no, I'm sorry. You just can't respond yet. You want to bring in a tard to contradict her testimony, correct?
Object. She's discussing a prior report. I would argue that whatever the.
I don't need to hear anything on that. I'm gonna overrule your request. And that's it. Thank you. All right. Do you have any, you can step down, ma'am. Do you have any other witnesses? Do you have any witnesses?
Do I need, I'm not gonna ask a question? Am I gonna ask a question or answer a question? Like, say.
Is he going to be called as a witness or do you want to just rely on the testimony so far?
Yeah, I don't have anything to say on
But
that.
ask Mr. Woods Johnson, time you have already to represent in this case, would you like to do that or would you like to remain silent?
All right, look, if you want to argue, make it quick.
Your Honor, the complaint indicated not only the. There was a no contact order. She indicated that she did see him at the household on May 15th, and she had gone there to telegraph her belongings. And she also indicated that she received text messages from him. In addition,
She got one text message that
Your Honor,
where he loaned her money, right?
in addition to that, Your Honor, I think it's really important for the court to take notice of the CPS allegations and the police contact she has had with him. I understand that you did not believe that to be contact, but the people would argue that that is indirect contact. It is a form of intimidation and a form of harassment. He did that following last.
How do I make the determination that that was a form of harassment when they haven't even concluded their investigation? There's nothing in a no contact order where a judge can preclude somebody from filing a CPS complaint. Now, he may have other issues of that down the road, and it may turn out to be false. And then that's going to hurt him immensely. But I'm not going to rely on that. Here's the bottom line. He violated the no contact. He violated the judge's order. The judge told him, or the magistrate lawyer, whoever that is, told him on May the 10th, you're not going back to Matt's Drive. For whatever reason, he chose to ignore the judge's order. That's a problem. That's a big problem. And then I don't care what kind of help you intended to give the victim. When a judge says no contact, they're not kidding. He means no contact. And you had contact with him. It's not a violation of the no contact provision for the victim to have contact with the defendant, but it is for the defendant to have contact with the victim, at least as this order was framed by the judge. Where does your client work?
You work for Amazon, it's a subsidiary of Amazon, you work full time, prior to season is coming up.
You can't do this. I'll let you guys address bond. What are you asking for?
Your Honor, because of that bond be removed.
No, I would ask for the person bond to continue. There has been no further contact. When this court appeared on the 19th of May, this court made it very clear not to have any contact. After May 15th, my client lost the telephone number, so he wouldn't answer the phone or have no contact. He was lost his home, moved out at this time.
You can see that on the 19th, I say that he may return to the property at 23652 Mance Drive.
He did.
And I said after 6:30.
And there was no issue.
I know, but here's the problem. I may or may not agree with that judge's order when somebody owns or is the leaseholder of a property and the other side is not. The problem is he violated the judge's order. You don't get to violate judge's orders. I'm revoking the release, forfeiting the bond. I'm going to set a reasonable bond that I think you should be able to post. But I'm telling you, 10,000, 10% is the bond. I'm revoking the release and forfeiting the personal bond. And I'm going to give you an earlier court date now that I earlier expressed, because if you can't post, you're entitled to be arraigned on the charges in the complaint within 1 week. So I'm making it June the 2nd at 9. Again, bond is in the amount of 10,000, 10%. They'll let you make calls if you don't have the money to post it, but you're not going to violate a judge's order. Do we understand one another?
Yes, Your Honor.
Good. Don't do it again. Do you have $1,000 to post?
$1,000 today, I can make some phone calls.
They'll let you make phone calls back there, but you're in custody until you can post it. Do not do that. You got me?
Yes, Your Honor.
All right, good luck. Have a seat there.
Number 15, Alan Waddell. Thank you for being patient for the last people who were in the docket. Thank you.
Front and center.
All right, so we have you here on a no valid operator's license. It looks like I'm still showing that it is expired. So what would you like to tell me today about the infraction?
Well, I'd like, Your Honor, if the court pleases, to certify the bond of subrogation, if you please.
Certify the bond of...
Yes, Your Honor.
Can you... So what would you like me to have certified?
The bond of subrogation.
What is the bond of subrogation?
You don't know?
Why don't you inform me? Is there a document that you have?
I can have the Justice Department send you one.
For what?
The bond of subrogation.
So, a subrogation agreement?
Subrogation is a bond.
Correct?
That's a bond that you place on my name.
I have not placed any bond on your name.
Well, this municipality most likely has.
You are Alan Lee Waddell?
Correct.
Okay. And so there's...
See, when this court is, if you hammer me, all that money in that bond goes to the IMF.
there is no bond. There's an infraction with a fine amount. So if that's what you want to tell me today, we're here for a contested hearing. I haven't heard anything that...
Latches and curs. Are you familiar with the Constitution? Latches and curs, right? Motion to dismiss.
Okay, motion to dismiss on what grounds?
On grounds that you do not know what you're doing. I'm sorry, Your Honor, you're supposed to know the law.
Okay.
Latches and curs.
All right. What legal authority do you have for your motion to dismiss beyond you don't think I know what I'm doing?
That will come from the Justice Department, Your Honor.
All right. Do you you were stopped on February 25th, 2026?
According to Eric, the Kelso cop.
Okay.
Is he present? Is Eric present?
Did you subpoena him?
I did, and
did you file proof of service of the subpoena?
Excuse me?
Did you file proof of service of the subpoena?
I did. I filed a notice of liability.
That's not a proof of service.
It's a certified sign. It's a signed affidavit.
What signed affidavit do you?
It's supposed to be in your possession.
I have it.
Okay. Have you read it?
Yes.
It's notarized.
Okay.
It's a notarized affidavit.
Indiana Bill of Rights. None of this is binding on this court.
Those are case law, Supreme Court case law. standing.
Indiana Article 1 Bill of Rights is not case law.
Well, we're applying it to
We are not
You-
applying Indiana Bill of Rights to Washington.
your
District
name will
Court.
appear here.
All right. Mr. Waddell, I have in front of me the officer's narrative indicating that he stopped you on February 25th, 2026, driving a maroon Chrysler PT Cruiser on the northbound 1400 block of South Pacific Avenue with its
Objection,
left
Your
and center brake light not functioning, initiated the traverse stop, identified himself verbally as Alan Waddell, stated he left his insurance back at his house and was unable to provide proof of insurance. The check of his DOL showed that it expired September 22nd, 2022. The photograph on Waddell's DOL record matched the driver, confirming his identity, and he issued the infraction. And you were warned about not having insurance and not having brake lights active. All right.
I informed the officer, Your Honor, at the time that there is no contract. The contract, the license, which is a contract, has expired almost 5 years ago.
Yet you were driving.
There is no contract.
You were driving on a public road. Okay, I'm going to find the infraction committed
no
at the
bearing
full
on it.
amount of $564. You will have 60 days to either pay in full or set up a payment plan.
I will sub this, and
What was that?
I will have to recommend it. I must recuse you, Your
Okay,
Honor.
you can file that with the, you
At this
can
point in
make a
time.
motion, but I've made my ruling at this point.
I'm motioning for a mistrial, and I'm going to recuse you
Okay, I'm
from this case.
denying those motions as they are not timely nor relevant at this point.
Under the
So your infraction
Constitution-
has been committed. If you would like to file motions to
You are
appeal
in direct
this,
violation
go
of the
ahead.
constitutional rights, Your Honor.
All right,
You
Mr.
are
Waddell, that'll be all for today.
All right, Mr. Waddell. That will be all for today. Oh, what a way to end. What a way to end. I get it. Those people. I don't know what I'm doing. There we are. Thank you, ladies and gentlemen. Thank you very much, Marty Duvall, and my good friend Hutch out there with Sovereign Legal Encounters. All you people, all you crazy folks. It's been an interesting show. And yeah. I don't even know what to say. That last guy, actually, I think the last guy probably what few brain cells I had are gone. They're just gone. Just trying to comprehend some of the crazy crap he was saying right there. But the first guy with Judge Wiggins, man, hiding out in the woods for 6 years just to avoid the police, and then having a series of family tragedies dragging you out of the woods. Look at that one right there. Oh, she's up to the couch. Keep an eye out for new videos coming out all day, every day. They come out about every 8 hours, so one should be coming out around 4 a.m. ish. Then another one about noon tomorrow, and then tomorrow again at 8 p.m. Central Time, 9 p.m. Eastern Time. Same Wolf Time, same Wolf Channel. We'll be right here, hanging out, doing the thing we do. Listen to Mama. Do what Mama says. She's right. She knows things. Ladies and gentlemen, while we're rolling on out, let's roll some credits, shall we? Thank you very much, my friend Hutch and Kiernoth. You guys are amazing. All you guys out there. Julie, Becky, Rhonda, Liz Good, Bromidicus, Jen Regier, Mama Wolfie, Northwest Dawn, Marty, Felix. Oh my God, I almost couldn't even make it through the list. I don't even know what to say. And just throwing this out there, there's a lot more from today. This was just a little taste of some of the crazy cases that were out there in the sphere, coming to you from place to place. There'll be more. Keep an eye out. You know, I'm your little foozle. I'm the guy who puts these little videos together for you. I'm your curator for this here channel at the Court Gallery. And ladies and gentlemen, I am out. Y'all have a good night. Does anybody know if Hutch has a video coming out anytime soon? Somebody should ask him. Oh, wait. Oh, hey, how are you guys doing? Why are you still here? What are we doing? Oh, hey, guess what? Sovereign Legal Encounters has a video coming out tomorrow morning, ladies and gentlemen. Keep an eye out. If you're watching this after the fact, just zoom on over there right now, since this is the end of this video, and watch it, because, you know, that'll be like 12 hours from now. And yeah, I got nothing else. I don't know why we're still here talking. This is my fault, isn't it? Yeah, it is. Bye. Who was it? Marty the other night was talking about every once in a while I come back and I do another one just because I'm crazy like that. Yeah, there you go. There's a good link right there. If you're not seeing the links, there's the links right there. Oh, hey, people, make sure you turn on your chat when you're watching this in replay. Oh, it might be a little late for that now. Yeah. Damn. Marty, do that thing you do.